If you're charged with a crime in Pennsylvania, here's what most people don't understand. The case can still get tossed out even when police, quote unquote, caught you. You even think, yeah, I did it. Because court isn't just about what happened, it's about what the government can prove and what they did to get that proof. I'm Frank Walker. I'm a criminal defense attorney here in Pennsylvania, and I've had cases dismissed or knocked out or dropped because the stop was illegal, the search went too far, or the paperwork was wrong, or even because the evidence just wasn't legally usable. So in this video, I'm going to talk to you about showing the real pathways to a dismissal, what has to break in a state's case where judges draw the line, and what we look for right away to put the prosecution on the defensive. Because if you walk in thinking, I'm guilty, so I'm stuck, you'll miss the deadlines and the motions that can end the case very early, and you'll talk yourself into deals that you never had to take in the first place. So let's start from the beginning. In Pennsylvania, just because you're charged with a crime doesn't mean you'll be convicted, whether it's a DUI, a drug charge, theft charge, or something a little bit more serious like homicide or violent offense. Your case is built on evidence, the process, and the procedure. And when any part of that process or procedure breaks down, the entire case can fall apart. Dismissals happen every single day for reasons most people don't expect. So let's walk through some of the reasons why these dismissals can happen. One of the most common ways cases get dismissed is through illegal searches. If the police didn't have a valid reason to search you, your car, your home, the evidence they find can be suppressed. That means it can't be used against you. So for example, let's say you're pulled over for a broken taillight. The officer decides to search your trunk and find drugs. If that search wasn't based on probable cause or your consent, it's likely unconstitutional. I had a client here in Allegheny County arrested after a traffic stop. The officer claimed he acted suspicious, and then he searched the car. But the dash cam footage showed no signs of impairment or suspicious behavior, and no real facts to support the officer's opinion other than his own hunch. We challenged the search. We filed a motion, and the judge ruled it was illegal. Case dismissed. It's over. The police have to follow the rules. If they don't, your case can be thrown out. In Pennsylvania, the burden of proof is on the prosecution to prove that you're guilty beyond a reasonable doubt, and that's a very, very high standard. Why? Because they're taking away your freedom. They're attempting to take away your freedom. I had a client in Westmoreland County accused of shoplifting. The store manager claimed she stole a watch, but there was no video, no witnesses who actually saw it happen, and no stolen property recovered from her. The only proof was a receipt showing that she paid for the socks, and then their belief that she must have taken something else. That wasn't enough. The case was dismissed. This applies in other charges as well. If the breathalyzer wasn't calibrated in a DUI stop, if the paperwork is missing, or if the police reports are sloppy, your lawyer can and should argue that the evidence doesn't meet the legal standard of proof beyond a reasonable doubt. Bottom line, no evidence, no conviction. Now, let's talk about witnesses. If the prosecution's key witnesses can't be found, they won't cooperate, or they change their stories, the case often falls apart right before their eyes or on the date of court. Let's say in bar fights, domestic disputes, or neighbor conflicts. Witness cooperation is everything. If the person who made the complaint backs out, or they forget the details, or they move out of state, prosecutors may decide it's not worth the fight. One client of mine in Washington County was accused of trespassing and damaging a neighbor's property. By the time we got to the hearing, the neighbor had moved away and stopped responding to the calls. The prosecutor was forced to dismiss the case. Without reliable witnesses, prosecutors often have no case. In Pennsylvania, we offer something called the ARD program, Accelerated Rehabilitative Disposition. I'll say it again, Accelerated Rehabilitative Disposition. This is for people with no prior record who are charged with nonviolent offenses like DUI or simple possession. Now, if you qualify, you agree to conditions like community service or counseling or do some classes or maybe some AA meetings or NA meetings. In return, the prosecution pauses your case. It doesn't dismiss it outright. It pauses your case. And if you complete the program successfully and all the requirements they ask you to do, the case gets dismissed and you may be able to get your record expunged. So one of my clients in Pittsburgh got caught with marijuana at a college party. He was terrified. His parents were terrified. It could ruin his future. We applied for the ARD program. We spoke to the prosecutor, we spoke to the officers and everyone else involved. He completed the program, the charges were dismissed, and his record was clear. If you're a first-time offender, this is worth asking about. This is worth doing the investigation and worth asking your attorney about. You have the right to speedy trial under Pennsylvania law. In most cases, that means the Commonwealth has 365 days, 1 year, from the date of your arrest to bring your case to trial. If delays are caused by the prosecution and not by you, your attorney can file a motion to dismiss for violating your speedy trial rights. Deadlines matter. And if the clock runs out, you can walk away even if you technically were guilty. Sometimes, even when the law's on their side, prosecutors choose not to move forward. They may decide your offense was too minor, or that you've taken steps to make things right even prior to your trial date, like paying restitution, writing an apology letter, or completing some type of counseling. I've seen this happen with low-level theft, minor fraud cases, and other nonviolent offenses. A quick conversation with the assistant district attorney, combined with proof that my client took responsibility, understood the consequences of their actions, led to full dismissals. Prosecutors have wide discretion, and you can use that discretion in your favor. If your lawyer presents the case in the right way, the prosecution may be open to letting it go. If you're guilty or you think you are, that doesn't mean your case is hopeless. Cases get dismissed in Pennsylvania for all kinds of reasons. Police-made illegal searches. The evidence is weak or the evidence is missing. Witnesses disappear or change their stories, or you qualify for a pretrial diversion program, or the ARD, which is, what is that again? Accelerated Rehabilitative Disposition Program. Or the state misses some deadlines, or the prosecutor decides it's just not worth pursuing this case. These are real legal tools. They work, but you need someone who knows how to use them. If this video helped you, don't miss the next video, The Hidden Rules of Gun Possession Law in Pennsylvania. If you or someone you know owns a firearm, you need to understand the rules that trip up even the responsible gun owners. Click over now to stay protected, and I'll see you over there.